Good afternoon. My name is David Tarpley. I am an attorney with the Legal Aid Society of Middle Tennessee and the Cumberlands, based here in Nashville, Tennessee. We're going to be talking today about home mortgages, what they are, what they consist of, what brings folks through our doors with mortgage problems, and a little of what we can do to help them when they do. This session is designed primarily for attorneys with little or no experience in handling mortgage problems. And the questions and answers which I've thought of come mostly from my own experience in dealing with younger attorneys and students in my own work. And I've tried to foresee as much as possible the questions you might have and the things that might be helpful in getting started in handling mortgage cases. So let's start with the question, what is a mortgage? And a fairly concise definition is that a mortgage is a contractual lien upon land to secure the performance of a payment obligation. The payment obligation may consist of simply a promise to pay or repay money, and that's in the form of a promissory note, or it may be in the form of, for example, an installment sale contract entered into with a contractor for the performance of work on the property. But either way, the mortgage itself is the instrument that creates the contractual lien upon the property itself. Several years ago, I was curious to know where the name mortgage comes from, so I looked it up. Well, the term mortgage is actually derived from two old terms from the Norman French, mort and gage. Mort deriving, of course, originally from the Latin, referring to death or repose. Gage was another term meaning lien. So literally, mortgage, as it came from the Norman French, meant dead lien or lien in repose. That's best understood by contrasting mortgage with another term that used to exist in the common law, but has gone out of usage over the last 100 years or so, and that was vive gage. The vive gage was a lien upon the living land, and that meant the fruits of the land. Timber, crops, livestock, minerals, etc. The things that the land produces. A lien upon those things was a vive gage, and a lien upon the land itself, that is the dead land, the land in repose, was the mortgage. Well, the term mortgage survives, and that's still, of course, what it is today. It's a lien upon the land itself to secure the performance of the debt obligation. There are two basic types of mortgage as used in the United States. There is the traditional common law mortgage, and there is the deed of trust. The common law mortgage is used in about 30 of our states, whereas the deed of trust is used in about 20 of our states, plus the District of Columbia, and that does include Tennessee. We have provisions in our law that allow the use of the deed of trust. Well, here is the difference. The traditional common law mortgage is a two-party instrument. It's an agreement between the creditor and the debtor, and here, of course, we're talking about mainly homeowner, that secures the payment by the homeowner of the money that the homeowner has agreed to pay. Now, that's separate from the debt instrument itself. The debt instrument itself, of course, is a promissory note or sometimes an installment contract, whereas the instrument that creates the lien is the deed of trust or the mortgage. Well, whereas the mortgage is simply a two-party instrument between the debtor and the creditor, the deed of trust is a three-party instrument. And three parties are named in the instrument. There is the creditor, the parties that loans the money, the debtor or homeowner who borrows the money, and there is a trustee. And the trustee's function is to enforce the deed of trust against the debtor, rather against the property. should that enforcement become necessary. Now, the theory behind a deed of trust, and for that matter behind a common law mortgage, is that the debtor conveys the legal title to the land in trust. In a traditional mortgage, it's conveyed directly to the creditor. In a deed of trust, it's conveyed to the trustee. But in either case, the conveyance in trust is of legal title only, not the equitable ownership, but the legal title only. And of course, the condition of that trust is that the debtor will comply with his requirements to repay and to do everything else that's required of him in the promissory note and the deed of trust. And if he performs fully and meets all of his obligations, then of course the deed of trust and the note are deemed satisfied and the deed of trust is released of record. Otherwise, if that doesn't happen, then the trustee is asked by the creditor or the holder of the obligation to enforce the deed of trust, and of course that is done through the power of sale provisions that are contained in statute and in the terms of the deed of trust itself, and we'll discuss that some more in a minute. I want to talk for a minute about the essential documents in any mortgage transaction. And as we all know, if we've ever purchased a house or attended a closing, the debtor gets a huge stack of papers, most of which he doesn't understand and most of which don't matter to him. Many attorneys have said to me, I have no idea what's in that closing pack that I got when I bought my house or I refinanced a few years ago. Well, there are 4 essential documents that all of us need to be able to spot and understand in order to be able to handle these cases. Now, there may be more, of course, but these are the 4 that are always present that we always need to look for. First is the debt obligation itself, promissory note, or perhaps an installment contract. Second is the mortgage or deed of trust itself, and that, of course, is the instrument that's recorded in the County Register of Deeds office. The third is the Truth in Lending Disclosure Statement that, of course, is required by the Federal Truth in Lending Act, and that contains the credit cost and terms disclosures that are required by the Truth in Lending Act and Regulation Z, which implements the statute. The fourth essential document is what we call the settlement statement, usually accompanied by a list of disbursements that are made by the settlement agent when the loan is funded, that is actually dispersed and paid out. And that settlement statement lists all of the money that is received by and or paid by the debtor. And if the transaction is a purchase transaction, that is where the debtor is purchasing a home, the settlement statement, of course, contains the same information for the purchaser and the seller, and that is everything they are receiving and from where, and everything that they are paying out. Let's talk about, since we're in Tennessee, what foreclosure under power of sale means. Again, I've already said that we are not a common law mortgage state in Tennessee. Now, there is nothing illegal about using a common law mortgage, but who would ever do it? The thing about a common law mortgage is that it must be enforced through judicial action. The only way to enforce a mortgage, a traditional mortgage in Tennessee, as elsewhere, is by filing a lawsuit and seeking a court order decreeing a sale after the court finds that the note is in default. The point of having foreclosure under power of sale from the standpoint of the creditor is to avoid having to file a suit. Now, in order to accomplish that, the state has to have provisions in the state code which authorize the parties to enter into an agreement that contains power of sale provisions. And we have those in Tennessee. The code does have specific provisions for power of sale through a deed of trust. And in essence, those are as follows. There must be notice to the debtor and any other lien holders on the property that the creditor is going to advertise and sell the property through the trustee because of the default. Junior lien holders, excuse me, other than the IRS, stand to have their liens extinguished if the senior mortgage is in fact foreclosed. Now, the underlying debt still exists, but of course, if the junior lien, for example, a second or third mortgage, is extinguished by foreclosure of the first, then that creditor is left holding nothing but an unsecured debt, which of course may be very little value to it, if any. In addition, the power of sale provisions of the Tennessee Code require publication. And the minimum requirement for publication is 3 successive notices published in a paper of general, it's either published or of general circulation in the county where the land lies. 3 successive publication notices are required, and the first notice must be published at least 20 days prior to the date and time of the scheduled sale. The publication notice must contain at a minimum the following. It must identify and give the contact information for the trustee who's doing the foreclosure. And that trustee may, and it is usually not the original trustee who was named in the deed of trust. It's usually what we call a substitute trustee. And a requirement is that before the sale be held, if it is going to be a substitute trustee who conducts the sale, there must be a notice of substitution of trustee executed by or on behalf of the owner of the debt, identifying the substitute trustee who is actually going to do the sale. The next requirement is that the debtor himself or debtors must be identified. The instrument that's being foreclosed must itself be identified by the information as to where it is recorded in the County Register of Deeds. It may be a book and page number, or as in Davidson County, it may be just one single 15-digit recording number. The notice must give the complete legal description of the property, not just an address, but the complete legal description. And the notice must specify the date, time, and place of the foreclosure sale, which of course is done by auction at public outcry. Most foreclosure sales in Davidson County, although not all, are done on the steps of the county courthouse. But wherever it's done, the notice must specify where that will be. Now, in Tennessee, as elsewhere, there exists an old common law concept that is still good law called the equity of redemption. And the equity of redemption is the old common law right of the debtor to redeem the property and keep it out of foreclosure by tendering to the trustee the full amount owed at that time on the obligation at any point up to the moment of the sale. Theoretically, the minute before the sale, if he shows up with funds in the correct amount. If that occurs, the sale cannot be held. It must be called off, and the trustee must accept on behalf of the creditor that it's working for the payoff amount. Now, there is another concept which is actually statutory, not part of the common law, and it's called the statutory right of redemption. Unlike the equity of redemption, which is a right that exists up till the point of sale, the statutory right of redemption picks up at the point of sale and extends for a year. And the statutory right of redemption is the right of the debtor to redeem the property that's already been sold by paying everything that the purchaser at the sale paid plus any fees and costs and expenses that have accrued in order to get the property back. In practice, this very seldom ever comes up because Unlike the equity of redemption, the statutory right of redemption can be waived in the deed of trust, and every properly drawn commercial deed of trust does waive the statutory right of redemption. So we almost never see this come up in fact. The only time I can think of it would come up would be if the parties entered into, say, a private mortgage transaction with a deed of trust drawn up that wasn't that well drafted and excluded any mention of the statutory right of redemption, then it would apply for a year after the sale. But every commercially drafted deed of trust intended for a mortgage that's put into the secondary market does have a waiver of the statutory right of redemption. Now, in connection with the equity of redemption, one of the duties of the trustee, remember this is the party whose only function is to enforce the deed of trust if it becomes necessary. The trustee has a statutory duty to provide to the debtor or the debtor's representative payoff information upon request. If the debtor requests it, the trustee must tell the debtor exactly how much it will take to pay off the mortgage lien before the sale. And the failure of the trustee to do this upon request is in fact grounds for an injunction issued by a court to stop the sale. Let's talk about defenses to foreclosure. And let me say at the outset that we don't enter into lawsuits to stop foreclosures lightly for 2 or 3 reasons. Those of us who practice in power of sale states that don't have judicial foreclosure, like Tennessee, are at somewhat of a disadvantage because our brethren who practice in judicial foreclosure states, and those are the states that, of course, use common law two-party mortgages, have the advantage that when they are defending a homeowner, there is a lawsuit already there, already existing, because the creditor had to bring the suit in order to seek permission from a court to do the foreclosure sale. So, of course, if the homeowner, through its advocate, has one or more valid grounds to attack the sale or to stop the foreclosure, they have only to raise defenses and, if applicable, counterclaims in that suit that the creditor has filed. Whereas in a state like Tennessee, where we don't have a lawsuit already going, if we're going to go to court to stop a foreclosure sale, we have to create the suit ourselves. And that, of course, raises logistical problems, financial pressures, time pressures, and, of course, where the debtor brings the suit to stop the sale, the spin is against the debtor from the outset. To establish that the presumption, not so much a legal but traditional presumption that the foreclosure is probably correct, is not in fact so. Excuse me. So let's talk about the defenses that the courts have traditionally addressed to foreclosure sales. First, and this is probably the most common question, well, what about price? And this is actually not a defense per se because it's really an attack on foreclosure after the sale. But inadequate price is not generally a ground to attack a foreclosure. There used to be somewhat of a common law rule in Tennessee that if a sale brought less than 50% of market value, that it was presumed to be an invalid sale for inadequate price. That has not been the law in Tennessee for some time. It's much more fluid than that. The best that we can say today is that if a sale has brought less than 50%, it's worth taking a close look at, but just the inadequate price alone will not be enough to set aside a sale. You have to show an inadequate price plus some other factor or factors that make the sale inherently unfair or inequitable. Enough said on that. defenses that apply pre-sale, we've already mentioned the trustee's failure to provide a payoff figure upon request. That's an easy one. Now, failure to comply with statute. We've already mentioned that the Tennessee Code does provide provisions for power of sale. There are certain requirements that must be met. If those requirements are not met, that is, if a sale is conducted that does not comply with all of the provisions of the code, it may be subject to attack. Now, that said, a minor variation from a statute where you can't show any actual harm to the debtor because of that violation may not be enough to set it aside, but a major variation from the statute probably will. For example, if you just ran 2 notices instead of 3. I've never seen that, but if that were to happen, that would definitely be a defense. Failure to comply with the provisions of the note or deed of trust itself, that's somewhat more problematic for the creditor and the trustee. The courts, on the whole, are somewhat stricter about holding the creditors and the trustees to the provisions of their own documents. Because after all, the promissory note and the deed of trust are the provisions of their agreement with the debtor. The terms and conditions that the debtor must meet and that the creditor and trustee must meet in enforcing the obligation are set out in those 2 documents, the note and the deed of trust. And if you can show that that is not being complied with, that can be grounds to enjoin a sale and also grounds to attack a sale after it has occurred. And again, the courts are somewhat stricter on the whole about holding the creditor's feet to the fire on enforcing the provisions of its own agreement with the debtor than they are simply making sure that every little detail of the statute was followed. We have to talk about servicer conduct, or rather perhaps misconduct, as justifying injunctive relief to stop a sale. Who is the mortgage servicer? Well, of course, it is the entity that services the mortgage, what the debtor will call his mortgage company, the entity that sends him his statements, that collects his payments, that handles his escrow account, that contacts him when he's behind, that may offer him some sort of relief in lieu of foreclosure, if that will work. In other words, it's the entity that the debtor deals with day in, day out. That is the servicer of the mortgage. We all know that the servicer may or may not be the owner of the mortgage. A very large percentage of commercial home mortgages today are not owned by the same company that services the mortgage. Mortgage servicing is a huge and very lucrative business in this country. And the big servicers, most of them own some loans, service some loans. They may service loans that they don't own. They may own loans that they don't service. The trading of servicing goes on constantly all around the country. Most of the time it doesn't matter to the debtor, of course, who owns the loan. As long as there's not a problem with the loan, he's paying it, the servicer is keeping its record straight, it really doesn't matter to the debtor who owns the loan. But in the background, it can matter, because if the debtor runs into problems and wants to get, say, a loan modification or a forbearance, the regulations and restrictions that the servicer has imposed that the owner of the loan, the creditor, has imposed on the servicer will make a great deal of difference as to what kind of relief the debtor will get. The kinds of servicer misconduct that we see most often that may or may not in a given case justify injunctive relief to stop a foreclosure include, for example, failure by the servicer to provide reinstatement or payoff figures upon request, the giving of confusing and inconsistent information to the debtor, and or wrong instructions to the debtor regarding payments to be made or not made, or the relief that's available to the debtor. A common problem is so-called two-tracking, which is the servicers, on the one hand, putting the loan on a foreclosure track while simultaneously talking to the debtor about a loan modification or some other relief that would avoid a foreclosure. And we often see both things going on at the same time. One day the debtor's getting a notice as to when his loan will be in foreclosure, and the next day a notice saying that he's invited to apply for a loan modification. And we sometimes see that continue all the way down to the date of a sale. It's called two-tracking. All kinds of servicer misconduct can give rise to a situation where a court may say, okay, enough. This is unfair, it's inequitable, it's giving rise to a no-win situation on the part of a debtor who might well otherwise be able to put this loan on track, and a sale will be enjoined. You have to remember that foreclosure is an equitable remedy. It always has been, even though it has statutory guidelines that the servicer and the trustee must follow. Foreclosure itself is an equitable remedy, and the courts do recognize equitable defenses to foreclosure as well as recognizing legal causes of action that can be asserted against the servicer or the trustee. So let's talk about some of the legal causes of action that we see that do from time to time find success in the courts. First, of course, is just plain old breach of contract. Remember that the note and the deed of trust set out the conditions of the contract between the borrower and the creditor. And if the creditor, through its servicer, is threatening or carrying out a foreclosure when the borrower is not in default, or under other circumstances where its doing so would be a breach of its own agreement, that's just a breach of contract and can be attacked as such. The servicer may well be guilty of negligent misrepresentation in the various things that it said to the debtor, which were misleading, confusing, and sometimes just plain not true. I had a case 2 years ago involving one of the biggest servicers in the country where my client, on the same day, received 5 letters from different branches, different departments of the same servicer, every one of them telling her a different thing about what she might be able to do or what was going to happen to her loan. Well, how in the world was she supposed to know what to do? But negligent misrepresentation may well be, if you can show the grounds for it, the factual grounds, a successful cause of action. Now, distinguish that from ordinary negligence. The problem with ordinary negligence in the mortgage context is that the courts have had difficulty finding that servicers have a duty of reasonable care toward their debtor clients. That sounds a little strange, I know, but that is the case currently. If you research the law, you'll find that courts time after time have struck down ordinary negligence claims on the ground that they do not find a duty, and of course, if there's not a duty, there is no breach of duty. However, duty is not a requirement for negligent misrepresentation. Another cause of action is estoppel. And of course, there are 2 closely related kinds of estoppel. There's promissory estoppel and equitable estoppel. Promissory estoppel arises when a specific misrepresentation or promise is made, which is then not fulfilled, and the debtor suffers a detrimental reliance. Equitable estoppel arises not necessarily from a specific promise, but from an overall course of conduct and representation by the servicer, which reasonably causes the debtor to rely to its detriment on an expectation that the servicer will do a certain thing, which then it doesn't do. Again, those are related but not identical causes of action, and the courts are recognizing estoppel as a valid cause of action against servicers. Another one well worth exploring is the concept of lack of good faith and fair dealing. Now, this is in effect a contract claim because it requires a contract to create a duty of good faith and fair dealing. We have a lot of good case law in Tennessee generally on the subject of good faith and fair dealing and what the lack of that on the part of one party or the other will cause in terms of a contract. Unfortunately, we have a dearth of case law in the area of mortgages. Excuse me. But I do suggest to you that good faith and fair dealing is well worth exploring when you have a factual situation which does seem to lend itself to that cause of action. I'll mention also the Consumer Protection Act. There is a difficulty here that will have to be overcome by any advocate who wants to attack a threatened foreclosure sale or one that's already happened through the Consumer Protection Act. There is a line of cases which holds that the Consumer Protection Act does not apply to the servicing of home mortgage loans. Now, the CPA itself doesn't say that, and there's no other provision of statute that says that. These line of cases all trace their origin back to a case that was decided about 8 or 9 years ago in Tennessee and really has nothing to do, nothing at all, with mortgage foreclosures. But the courts have tended to string cite cases back to that one case, which was called Purcell versus First American Bank, which was actually a case having to do with a squabble over personal possessions that were in a car that was repossessed, and have concluded somehow from that case that the CPA does not apply to mortgage servicing. I personally hope to see the state Supreme Court perhaps address that issue sometime, which they have not. I'll be interested to see if they do, what their holding on that will be. Caveat, and some people don't know this until they get hit with it at the last minute. There is in Tennessee an old statute still on the books that says that if we are going to seek an injunction against a foreclosure sale, we must give 5 days advance notice to the trustee of the date, time, and place of the hearing on the request for injunction, which of course in terms of civil procedure actually means a TRO, or temporary restraining order request. Many courts are very insistent that that be complied with. Occasionally a court in very exigent circumstances is willing to just waive that. I had such a case 3 years ago where we literally didn't have 5 days, but we had good grounds, and the court was willing to ignore the statute. But don't ever expect that to happen, if at all possible. If you get the case in time, be sure that the suit is filed and you have your ducks in a row so that you can give 5 days advance notice to the trustee of when and where you're going to apply to the court for your temporary restraining order. Otherwise, there's a very good chance that you won't even get to argue it. We all know, I think probably, that a bankruptcy filing, either a Chapter 13 or a Chapter 7, or even a Chapter 11 if you have one, will automatically stay a foreclosure sale simply because the provisions of the bankruptcy automatic stay will cover that. The only requirement as such for invoking the stay is that a bankruptcy filing notice be given to the trustee before the actual sale takes place. And of course that just means actual notice in whatever form it's given. Usually the attorney for the debtor gives notice as soon as he or she has filed the case. Of course, there can be more than one motive in a bankruptcy filing to stop a foreclosure sale. The Chapter 13, of course, is commonly used where the debtor hopes to actually cure the arrearage and put the loan back on track through payments through the Chapter 13 plan. A Chapter 7 straight bankruptcy filing may be done in order to acquire additional time, perhaps for a cash redemption, but more likely to arrange for a sale of the home at or close to market value so that the debtor doesn't lose his or her equity in the meantime. Okay, we've alluded somewhat to setting aside sales in the course of talking about seeking to enjoin sales. But let's talk more about that. A great deal of my work these days with homeowners is actually looking for ways to get loans reinstated when the sale has already been held. But first we have to talk about what happens to the debtor after the foreclosure sale. The debtor first needs to understand that just because a sale has been held, he's not from that reason alone going to be put out of the house. What the sale does, of course, is transfer ownership of the home. And in nearly all home foreclosure instances, that means a transfer either to the servicer or if there was a guarantor, such as Fannie Mae or Freddie Mac, a transfer to the guarantor. But it doesn't mean that the homeowner has to leave the home at that point. First, there must be an eviction suit brought against the homeowner, and of course that has to go to judgment. In Tennessee, our eviction suits are called detainer warrants, and they're nearly always filed, of course, in General Sessions Court. And the object of the detainer is, of course, for the new title holder to gain an order of possession of the home. And we probably all know what the time limit is in General Sessions. Once the judgment goes down, after 10 more days, it's final. And after that, then, of course, the plaintiff can take the necessary action through the sheriff's office to dispossess the homeowner. Now, where does an attack on the preceding sale fit into all this? Well, it fits in here. One of the little quirks of common law in Tennessee is that in a detainer suit, issues contesting title or right to title cannot be raised. That said, the common law in Tennessee does recognize the right of the former owner who is still in possession, the homeowner who has now been foreclosed on, to dispute, to contest a detainer on the proposition that the preceding foreclosure sale was wrongful. If the debtor can show that the preceding sale was wrongfully conducted, it shouldn't have happened, then although the debtor cannot, as a part of the detainer suit, undo the sale and get title back, the debtor can defeat the creditor's attempt to gain possession. Well, that said, the debtor must then affirmatively attack the sale one way or another. If the debtor is already facing a detainer suit in General Sessions, the way that's done is to take the detainer suit to circuit court, either on the de novo appeal, which of course we have from General Sessions to circuit in Tennessee, or perhaps through the mechanism of the removal statute, that is the removal of a case from General Sessions to circuit without a hearing in General Sessions. That does require advance notice to the plaintiff, in this case the creditor seeking possession, and either an agreement of the parties or a hearing by the General Sessions Court to determine whether it should be removed. And there are some statutory requirements that the party seeking removal has to show. But whichever way it's done, the case is taken to circuit court, and at that point, of course, the debtor can not only defend the detainer, but can also counterclaim. Here the debtor can bring its affirmative claims through the counterclaim to attack the foreclosure sale. Now that said, when is it too late to do that? Well, it's too late to do that when that detainer judgment becomes final. There is Tennessee appellate case law, more than one case, that says that once that detainer judgment becomes final, If the debtor has not at that point in time raised defenses to foreclosure, consisting of a tax on the preceding sale, then after that it's res judicata. We all remember what res judicata means. It means it's too late. The case is over. The debtor had the opportunity. The debtor cannot, after that, assert through an independent suit grounds to set aside the sale. The day that that judgment is final is too late to attack the preceding sale. Word to the wise. If you have a client who is on the receiving end of a detainer suit, and it appears to you that there are grounds to attack the preceding sale, be sure and jump right on top of that detainer, either get it appealed to circuit for de novo treatment or removed, and handle it through that case. Don't wait. Okay, I want to make a couple of more points before we end. A very useful tool for homeowners and their advocates to use in getting information about the servicing history on loans is the so-called qualified written request, or as we call it, QWR, that we have the right to under the Real Estate Settlement Procedures Act, which is part of federal law. And that's contained in 12 U.S. Code. And what this says is that the debtor or the debtor's advisor can send a written request to the servicer. It has to be to the designated address for that, and the servicers have to provide that, although they don't have to do it very conspicuously, so it has to be searched for sometimes. But the proper request sent to the proper address within that servicer's network triggers an absolute requirement under federal statute that the servicer provide all of the requested information about the loan servicing history that that servicer has within 30 business days of receiving the request, but it's really 45 because all the servicer has to do is send a letter that says, oh, we can't finish it in 30, but we can get it to you in 45, and that gives them 45 days. That said, they must comply. Now, the qualified written request must contain a general statement as to why the debtor wants the information. The reason being that that's supposed to help the servicer identify what specific information will help the debtor to understand whatever the debtor is trying to find out. It doesn't have to be a long, detailed explanation, but some general explanation of why the debtor is seeking the information. It is free. The servicer cannot charge for it. And this part of RESPA, that is the Real Estate Settlement Procedures Act, does carry a provision of private enforcement. There is a private cause of action that any individual can bring, and of course it is a federal claim, so it can be brought in federal court, or a servicer can remove it to federal court if it's brought in state court. But the debtor can enforce a QWR and can seek damages for noncompliance. Another thing we ought to mention in passing, although we're not going to dwell on it, is under Truth in Lending, of course, which is another federal statute, the right of statutory rescission. Now, this applies in certain types of home loans. It does not apply to an acquisition loan where the debtor purchases the home. It does apply anytime that a debtor is obtaining financing, credit financing, on a home that the debtor already owns. It may be a refinance of a mortgage already owed, or it may be the debtor is taking out a loan that the debtor owns free and clear and is putting on a mortgage where one didn't exist before. Either way, it must be credit against a home already owned. If certain provisions of Truth in Lending in connection with disclosures are not complied with, then under the rescission provisions of Truth in Lending, the debtor has a right to rescind that loan up to 3 years after it was consummated. Otherwise, the debtor only has a 3 business day right of rescission. But if the debtor has a delayed right of rescission because of Truth in Lending violations, certain Truth in Lending violations, then one of the effects of that rescission is that the lien is void. And of course, that will provide a defense against a foreclosure because you can't foreclose on a void lien. Be very careful in exercising the right of rescission, both on the substantive grounds and is it worth it. And note that in the Sixth Circuit, there is a fairly recent case involving the Bank of America, Lee versus Bank of America, in which the Sixth Circuit has said that you can't seek to rescind a loan simply on the debtor's assertion that at a later time he examined his closing package and found that he didn't get the right number of certain documents he was supposed to get, even though the regulation says that that is a violation which triggers the right to rescind. In the Sixth Circuit, no, it doesn't, thanks to Bank of America versus Lee. All right, we've talked about various things, and we've probably gone long enough. Let me say that, and especially if you're handling a pro bono case, but not necessarily, the attorneys at the Legal Aid Society who handle home ownership and foreclosure issues are always glad to try to help you. We've seen a lot of this stuff. We've handled a lot of it, and we're glad to share what knowledge or experience we have gained with any of you who are handling a case in this area and are not familiar with it and are wondering just what you're looking at or what you're dealing with and what, if anything, should be done. So please feel free to contact us anytime for that sort of advice or chat. So I bid you good day. Thank you.